Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer series. And today's program, Get a Warrant. We are going to look at crazy, funny, bizarre, sad at times, but just outlandish and absurd Fourth Amendment cases, situations where the police should have got a warrant. So you're going to get a bit of an overview of Fourth Amendment law. You're going to have a good time laughing, sit back with a cocktail and enjoy. Before we get started, though, let me talk to you briefly about our Curious Lawyer series and what it is. The Curious Lawyer you can think of as edutainment. This is not your normal, stressful, burdensome, technical, continuing legal education where you are going down the paths that you may live and practice in all the time and getting up to date on the latest changes to the statute or whatever it may be, stuff that can often be dry and boring. This is different. We look to take really fascinating legal issues or social issues and intersect them with the law to let you get a completely different interdisciplinary, multidisciplinary perspective on educational topics. So you can see some of our topics. Dog law. It's allowed us to look at all manner of issues across contract law, tort law, property law, trusts and estates law that give you your education, but intersecting it through dogs, our favorite furry friends, to understand how dogs fit in our legal landscape. We've done CIA law. We've even looked at whether there's a little corner of Yellowstone National Park where you could get away with the perfect crime because there's no jurisdiction to indict anyone. Don't go murder someone there yet. Watch my program, please. In any event, that's what the Curious Lawyer series is, and today's program is Get a Warrant. So sit back with your cocktail, get ready to laugh, and let's get going. The big picture question that we are going to ask in today's program is, how did we get from the focus of the framers with this novel, significant Fourth Amendment that was there to deal with the horrendous abuses that they were suffering at the hands of the English crown? How did we get from there to the 21st century where we are now talking about Fourth Amendment cases today, such as, and here's the list as you can see on our slide here, police seizing sleeping dogs from their beds. Divorce court judges literally going to search the home of the parties in a case before them, going from the bench to the home in 15 minutes to conduct a search. It's true. You're going to see what happens, though. Police super noses. Can they really smell marijuana in a little jar from a moving car across the freeway? They've claimed it. We'll see if you need a warrant. What about you call 911 to get some medical help, and it turns out the police overrun your home and search everything? Or loud sex, warrantless entries, and arrests. What about DUIs in your own garage? Literally, your own garage. Or how about this? Getting strip searched down at the police station when you're arrested for violating a dog leash law. Finally, we're going to look at whether you need a warrant when the home turns into a strip club. So we will end this program today with the same basic slide, and we're going to answer all these questions as we have this fun little walk through the Fourth Amendment today, and we're going to tell you which of those situations you need a warrant and which you don't. But first, we're going to do a little bit of history. We got to sit back in time, contextualize the Fourth Amendment, what it is, how it came to be, so that we can fast forward in time to these funny, absurd cases that we now confront within the realm of the Fourth Amendment. So here's our history slides. They've all got the black bar along the top, and now we're going to get a little more serious and go back to the political thought at the time of the colonies. The basic tenet, of course, is that every man's house is his castle, and that was the sort of root idea of English political thought at the time that was being followed by the colonies. And so you can see on our slide here the case of Entick versus Carrington. This is a 1763 case. And the basic facts are as follows. Some officers entered the home of the defendant. They were looking for political subversive material. They had an ostensible warrant. He was unhappy, so he sued, and the English courts held that the warrants amounted to a discretionary power given to messengers to search whether suspicions may chance to fall. If such a power is truly invested in a Secretary of State, and he can delegate this power, it certainly may affect the person and property of every man in this kingdom, and it's totally subversive to the liberty of the subject. Now, this was later identified by the U.S. Supreme Court as a great case from England that at root underpins our Fourth Amendment, and it helps frame what our founders were thinking about. That much we've learned from the 1886 case of Boyd versus United States. So let's move forward in our history now from the time of the English and what they were confronting in England with warrantless searches and the like, and let's get to the Republic's founding. So, of course, what happens is you will remember your history is that the English authorities were trying to enforce their revenue laws, and so they issued what were known as writs of assistance. Now, writs of assistance basically were general warrants that allowed the bearer of the warrant to go into any home or place, cavern, tavern, you name it, whatever it may be, to go and search and seize, ultimately, prohibited and uncustomed goods. And then to also command any subjects to assist in those endeavors in terms of searching and seizing. So in the colonies, James Otis attacked these writs on libertarian grounds, basically, in 1761, and asserted that these authorizing statutes had to be invalid because they conflicted with England's constitution. Now, he lost in that legal challenge, and the writs were issued and used, but his arguments became heavily cited in the colonies leading up to the Revolution. So now we get to Virginia and Massachusetts, and they issued declarations of rights. And their declarations of rights in the colonies of Massachusetts and Virginia expressly forbade general warrants. They demanded that all searches be reasonable. This led, of course, at the Constitutional Convention to the introduction by Madison of what ultimately became the Fourth Amendment. And so you can see on our next slide here, proposed and final Fourth Amendment, we can look at some of the language that was knocked around at the time. And so what we see is that it was, as originally proposed in the House of Representatives, the draft contained only one clause, and this directly imposed limitations on the issuance of warrants, but it imposed no express restrictions on warrantless searches or seizures. And this was the language. The rights of the people to be secure in their persons, their houses, their papers, and their other property from all unreasonable searches and seizures shall not be violated by warrants issued without probable cause, supported by oath or affirmation, or not particularly describing the places to be searched, or the persons or things to be seized. Now, as of course the Fourth Amendment was ultimately adopted, it ended up containing two separate clauses. The first clause essentially protects that basic right to be free from unreasonable searches and seizures. And on the other hand, the second requires that warrants be particular and also be supported by probable cause. And so here you have it, our glorious language of the Fourth Amendment. On our slide it says, and this is quoting the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Quick sidebar here. Does it apply to the states? Of course, remember the Bill of Rights was in the original Constitution, and it applied to the federal government. And so we, of course, dealt with, after the adoption of the Civil War amendments, after the Civil War, the 13th, 14th, 15th Amendments, the idea of the incorporation doctrine, whereby the idea is that the protections of the constitutional amendments, the first 10, the Bill of Rights, that previously had only applied to the federal governments and not the state governments. The question then was raised, okay, by adoption of the Due Process Clause, for example, of the 14th Amendment, have we now incorporated by reference through that clause and made applicable to the states the Bill of Rights and those amendments? In other words, does the prohibition against unreasonable searches and seizures only apply to the federal government, or does the federal Constitution also say, no, it applies to states? Of course, states probably have similar amendments, but nonetheless, maybe one didn't. So the question is very, very important to control sort of a state's behavior. And the basic test is as follows. And this comes from the Griswold case, and you see the quote there on the page, but it's the idea of fundamental rights that are rooted in the tradition and conscience of our people and are implicit in the concept of ordered liberty. These are applied to states via the 14th Amendment. And this, of course, is Griswold. And the question then is, the Fourth Amendment, well, it's been incorporated. And that was done in the case of Mapp versus Ohio in 1961 and Wolf versus Colorado in 1949, and basically upheld and applied that both the substantive standards that come from the Fourth Amendment, probable cause for a warrant, no unreasonable searches and seizures, that applies to the states, but also the resulting exclusionary rule, such that if things are unlawfully obtained by the police, they cannot be used in a criminal prosecution against the defendant, you, me, or anyone. So let's just take a quick look at one of the early cases from 1914 in the early 20th century before we start getting into police seizing dogs and judges leaving the bench to go search our homes. So here's the case. Check it out. It's Weeks versus United States, 232 U.S. 383, 1914. And basically what happened is the police, they're looking for someone who they think has got subversive material and the like. And so they go to the house, the defendant's not there, but the neighbor says, hey, I know where the key's kept. It's up above the ledge or whatever. And so the police say, cool, thank you. They take the key, they go and they search. And as they're searching, they find various papers and articles and other objects there, which they then seize after searching, and they turn them over to the U.S. Marshals. So later that day, police return with the marshal because he thought, hey, maybe I can find some additional evidence. And so they searched the room, and then they carried away certain letters and envelopes that were found in the drawer. The defendant got indicted and convicted of crimes, and those don't matter for our purposes. But here's what happened, because the defendant said, all of that stuff violated the Fourth Amendment. You don't get to use that against me. Supreme Court took this seriously and said, the principles laid down in this opinion affect the very essence of constitutional liberty and security. It is not the breaking of his doors and the rummaging of his drawers even that constitutes the essence of the offense, but it is the invasion of his indefeasible right of personal security, personal liberty, and private property, where that right has never been forfeited by his conviction of some public offense. It is the invasion of this sacred right. And so this really is sort of where we stand as we now are in the 21st century with all our modern technologies and the like. But this is a sacred right in terms of the government not being able to invade our personal security, personal liberty, private property without a warrant and upon probable cause. So the case was reversed. They needed a warrant to be able to go and do that. Conviction vacated. This, of course, lets us fast forward and wonder how we got from these lofty Fourth Amendment issues dealing with the revenue laws and the early republic and all this heady, complex, political, philosophical stuff on the Fourth Amendment to protect us from terrible government behavior. And we fast forward to today and we're looking at cases involving when Pasadena's police seized Toby the Beagle from his dog bed. You can't make it up, but it's true. Did they need to get a warrant? Let's take a look. The case, as you see on our slide here, is Conway versus Pasadena Humane Society, reported at 41 Calap 4th, 167. It's from 1996. And so here's the basic facts. Toby the Beagle, he's roaming the streets of Pasadena one day and some police see him. Now, they recognized Toby and they knew that he belonged to the Conway family. And they saw Toby as they started following him, run back to his property. He goes up the driveway and he goes into his backyard. So what do the police do? They go to the home and knock. No one answers. So then what do? Well, they decide they're going to go around back and see where Toby is. And they go around back and they see, oh, the back door's open to the house. It's open, about 2 feet or so. So at this point, what did the police decide to do? No one was home, apparently. Couldn't find Toby. He's obviously gone in the house. Did they elect to shut the door so maybe he doesn't run away again? Or, pull the door close to being closed, something like that? No. The police decided to enter the home to go and seize and fine Toby because Toby had been running at large in violation of a city ordinance. So they went in to fine Toby and seize the poor dog for breaking the leash law. It's not a joke. This is real. So they enter the house and they proceed to search all the rooms. They go and look in all the closets, the bedrooms. They look under the beds. And as they look under the bed, they can't find Toby. And then they find Toby lying on a bed, sleeping. Poor little Toby. Toby the Beagle. He's hanging out, napping. So what do the police do? They take Toby to the pound. But it gets worse. The Conways then get charged with violating the city ordinance. Now, they pled nolo contendere, and they got a 2-year probation sentence. That's pretty brutal, but okay. And it took 4 months to get Toby back after the seizure. So the poor family now has had their dog put in a pound for 4 months when the poor thing was sleeping on the bed after the police came in and entered and searched and took the dog. So this gets challenged in a civil rights challenge. And what the court in California ultimately held is that this dog did not pose a danger. And so that there was no basis to justify dispensing with the warrant requirement to enter and seize that dog and yank him off to the pound for the violation of City Ordinance 123, the leash law. So there you have it. Police entering homes to get beagles. Can't imagine the founders were thinking about that when they passed the Fourth Amendment. Now let's look at the other side, because sometimes the police may not need to get a warrant. And this is the case of the abused dogs. It's People versus Chung, reported at 185 Calap 4th, 247, 2010. This again comes out of California. And here are the basic facts. The neighbor to a unit in an apartment building calls the police one day and says, hey, look, the unit above me, I hear all these crying dogs, lots of crazy noise, howling, screaming, moaning. It doesn't sound good. So what do the police do? They go out to the apartment, they knock on the door. Now, the guy who opens the door, Mr. Chung, says, I don't know any dogs, don't know what you're talking about, no dogs here. But the police heard whimpering of dogs coming out of his apartment. So the police said, look, the guy's lying. There's an animal in distress at this point, in sort of imminent danger of some kind from the sounds that were reported and that we are now hearing firsthand. So they enter and they search. And what do they find? This is nasty. They find a dead dog in the freezer, and they find a profoundly injured dog on the balcony. The frozen dog in the freezer had literally been beaten to death, sadly, and the dog on the balcony had serious head trauma. So the defendant was arrested on the spot and put into criminal proceedings, but he challenged the evidence as basically fruit of the poisonous tree. He said, you didn't get a warrant, you couldn't come in. So the issue then was, does the exigent circumstances doctrine apply to dispense with the warrant requirement? Is this a situation where, like Toby the Beagle, for example, the police should have got a warrant and they couldn't dispense with the warrant because it was an exigent circumstance? And of course, the rule is, if there is an exigent circumstance such that the person may escape, evidence could be destroyed, those types of things, such that we don't have time to go get a warrant, we can dispense with the warrant requirement and make the search and seizure as needed, right? Toby the Beagle, they needed a warrant. Mr. Chung said you needed a warrant. What did the California Court of Appeal hold? Nope. Animal cruelty violates the law, and here the whining dog triggered the exigent circumstances doctrine that allowed the police to dispense with the warrant requirement so as to protect animals in imminent danger. And that's at pages 254 to 255 of that opinion. Now, let's go back to, since we're in the realm of dogs in the Fourth Amendment here, let's go look at a case coming out of the Eighth Circuit. Get a warrant? Well, let's find out. What happens when police strip search you down at the station because you didn't have Sam the dog on a leash? You heard it here, it's true. This is the case of Jones versus Edwards, reported at 770 F. 2nd, 739, coming out of the Eighth Circuit in 1985. So here are the basic facts. Sam the dog's wandering the neighborhood, and the police, they knew Sam, they'd seen him before. They also knew who owned Sam. So as the police were going to try to get Sam, Sam kind of, went running, scurrying off home, and he kind of runs into the garage. So the police knock at the front door because they want the identification and some, other information about the owner of the home so that they could fill out their criminal charge that they were going to charge the owner of Sam with for, not controlling his dog on the leash law and letting him roam the neighborhood. Well, so the police knock on the door and they say, we saw your dog running around the neighborhood. We need your ID. What does the owner do? Slams the door shut in the police's face. Now you can imagine if someone knocks at your front door, you open it, and it's a policeman saying, your dog was running around, I need your ID. You could imagine being a little perturbed and saying, yeah, whatever, go away. Maybe even think the whole thing's caught in candid camera, made up junk. Who knows? But in any event, he slammed the door in the police's face and said, get lost, basically. So what happened? The next day, the police, not happy. I guess the lesson here is don't slam the door in the police's face. I don't know. But in any event, the next day, the police return with a warrant in hand, and they arrest him. And they take him down to the police station. Now, remember, this is like a minor infraction of some kind, the leash law thing. And they get him to the police station, and then they start making him strip so that they can search. And he's getting angry and frustrated, but they say, nope, we're doing a strip search, including visual exams of his anal and genital areas. Like bend over and cough and all that. It's crazy. This poor guy is the leash law, and he's now, getting visually strip searched. In these brutal ways. What did the Eighth Circuit hold? Jones was arrested for failing to sign a summons and complaint arising from a leash law violation. Hardly the sort of crime to inspire officers with the fear of introducing weapons or contraband into the holding cell. In addition, officers had no other reason to suspect Jones was harboring these items. He was arrested early in the morning at his home and was not suspected of other crimes. That is, he broke the leash law. You think the guy's got a bag of cocaine, up his anal, up his butt? I mean, come on, it's crazy. But in any event, that's what they thought. And as the court went on, officers were with him from every moment after they read him the warrant. They watched him dress and go to the bathroom even, thereby eliminating any chance that he might have secreted a weapon inside his personal glands, right? Private sexual genital glands. So, as the court held, the Fourth Amendment does not allow jail officials to strip search someone charged with violating a leash law when there's no basis whatsoever to think that that kind of a search could yield anything. The mere act of being arrested for a leash law means we should all be good in America now if the rest of our nation's circuits and state courts are following Jones v. Edward. If you get busted for violating the leash law, at least I think you get to keep your underwear on. But stay tuned. All right, get a warrant. This is one that'll just blow your mind. What happens when you're in divorce court and your divorce court judge decides to go down to your home and do a little bit of a search? Believe it or not, but it's true. This is the case of Gibson versus Judge Goldston. It's reported from Federal District Court, West Virginia. This is a July 13th, 2022 summary judgment decision. You got the case number there if you want to go look it up. It's a fun one. So basically what happens is as follows. There's a divorce. Husband and wife get divorced, and there's this property allocation. And of course, I'm sure as happens in all these situations, everyone's complaining against everyone saying, oh, you didn't give me this, you didn't give me that. What we were supposed to divide up the CDs, the DVDs, whatever. You kept the good albums, I want them, whatever. So in any event, there's a contempt hearing that's brought by the wife because apparently the husband didn't hand over some property he was supposed to hand over. So there's a little hearing at court. They all show up. The husband doesn't have a lawyer, but he shows up, pro se. And at the hearing, the judge says on the bench, you know what? We're going down to your house now. I'll see you all there in 15 minutes. And quite literally, she walks off the bench, gets in her car, and drives to the house. So husband drives to the house too. Judge brings her bailiff. The bailiff calls the police to arrive also. So they arrive at the house. And so what does the husband say? The husband says, Your Honor, footnote, this is nuts, he says. But I think what he said probably more politely was, you're disqualified. You're now a witness searching and seeing what's in my home and what isn't. You can't be the judge anymore. You should be disqualified. Motion denied, judge says on the front lawn. The husband says, cool, you're not entering my home. I want you to have a warrant. I will not let you come in. And what does the judge say? Oh, yes, I will. Let me in that house, or the bailiff here is going to arrest you for being in direct contempt of court. Now, the judge later actually even admitted that she threatened him with arrest if he refused to allow her and others into his home. So the bailiff even saw and said that, yeah, I saw the judge threaten Gibson with arrest. And that me as a sworn on-duty police officer, I'm the bailiff of the court with arrest powers. I would have obliged and effected that arrest if he had not let us go and enter the home and search. And like I said, the police even arrived to assist. So you've now got all these people down getting ready to rummage around some guy's home because the judge wants to see what's in the home, I guess. Just can't make it up. In any event, the judge and the bailiff and the police then enter the home and they search it for about half an hour. And there's a hilarious video online. If you go to YouTube and do a little search, you can find it. The judge even gets in his recliner chair and just starts rocking, As everyone's searching, she's enjoying Gibson's recliner chair. And the husband whips out his cell phone and says, I'm filming this. The judge says, no, you're not. You must cease recording now and surrender your cell phone to my bailiff, which he then had to give up his cell phone. Now, the bailiff himself was actually recording it, which is why we have some more video footage of this. In any event, the search, what happens? They find a whole bunch of personal property and they take it into custody. Now, they didn't even inventory it at the time. And so this led later to a federal civil rights lawsuit for the whole thing and the behavior, but also for never returning some of my basic property since they didn't even inventory what they were taking, which seems to violate, obviously, basic police standards. The judge said, I'm a judge. I have absolute immunity. You can't sue me. I'm a judge. What the federal district judge said is, and he posed the question, does a judge normally execute a search warrant or personally search a residence? To ask the question is pretty much to answer it. Nope, judge, you don't get judicial immunity. That was an illegal search. Should have got a warrant. So there you have it. If you're in West Virginia, I guess you want to be careful going to divorce court because apparently Judge Goldston Had done it 10 or 11 times before in other cases. Seems to be her thing, I guess. Going to check out people's homes. Now we're going to look at the case of the DUI in the garage. This is Lang versus California. Went up to the U.S. Supreme Court. There you've got the site from 2021. Here are the facts. Lang's driving along one day listening to really loud music with his windows down, and he's repeatedly honking the horn. He's probably like going, Guns N' Roses, go, 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 welcome to the jungle, all that, right? Well, an officer sees this and says, well, I'm going to tail this guy. It's kind of weird. And the officer turns on his overhead signal eventually, telling Lang to pull over. Now, at that point, Lang was 100 feet from his home, which is literally 4 seconds of driving time. Just imagine. You're 4 seconds away and the lights go on. 1 1,000, 2 1,000, 3 1,000, 4 1,000. You're really close. You're basically in your driveway. So what does Lang do? Pulls into his driveway, pulls into his garage. He's like, I'm out of here. Well, the officer follows Lang into the garage and begins questioning him. The officer sees signs of intoxication. He puts Lang through some field sobriety tests, and Lang fails. Now, they also did a later blood test that showed that his blood alcohol content was actually 3 times the legal limit. Dude was drunk, so he gets a DUI charge. And he moved to suppress. Now, the motion to suppress was based on the idea that you had a warrant. You just can't wander into my garage and start administering DUI tests to me. I'm in my garage, driving drunk in my garage, apparently, or so he said. The motion was denied, but it went up to the Supreme Court. What did the Supreme Court say? Well, Lang's right to be secure in his home is critical, and the exigent circumstances doctrine is narrow when a minor offense alone is involved. Police don't usually face the kind of emergency that can justify a warrantless home entry. And so here's the quote. The flight of a suspected misdemeanant does not always justify a warrantless entry into a home. An officer has to consider all the circumstances in a pursuit case to determine whether there is a law enforcement emergency. On many occasions, the officer will have good reason to enter, maybe to prevent imminent harms of violence, destruction of evidence, someone escaping from the home. But when the officer has time to get a warrant, he must do so, even though the misdemeanant fled. And so the Supreme Court reversed the case. Now, it didn't say, let's be clear, it didn't say you can drive drunk into your driveway and be free to do it because you got to get a warrant every time. What they basically said is that the way the lower courts coming out of the California courts had handled the case, the California courts just said, whatever. You can always go into someone's home if it's someone fleeing. And what the Supreme Court said is, no, we don't have that kind of a categorical rule. When you're talking about minor offenses or misdemeanor type offenses, we got to balance this and make sure, did you really need to enter or not? So the case got sent back. So the case of the DUI in the garage, do you need a warrant? Maybe. But what about DUI and blood draws? This brings us to a case from Idaho. The Idaho Supreme Court in 2022, the case of State versus Blancas. It's reported at 170 Idaho 631. And so here are the basic facts. The defendant Blancas is driving along and Idaho State Police Officer Elverud, pulls him over because he was swerving. The defendant reeked of alcohol. He had slurred speech, he had red eyes, guy was drunk, right? So officer says, Mr. Blancas, you're driving under the influence. I'd like to take a breath test. And he says, okay. And so the officer does 4 breath tests. Now, one of them produced a valid result. Can't imagine what was going on with that breathalyzer, but it only worked once apparently. But it showed that his blood alcohol content was 3 times the legal limit. Why it didn't work the other 3, the record doesn't show. So what did the police officer do then? Did he arrest him because one of the tests shows you're drunk? No. What the police officer did was then take Mr. Blancas to the hospital to get a blood sample. Now Blancas said, I'm not giving you my blood. I did the breathalyzer, but I'm not giving you blood. The policeman then tried to find some on-call magistrate judge to get a warrant. Couldn't find the on-call magistrate judge. I guess the on-call magistrate judge was off call, right? Couldn't get him. So the policeman says to the hospital staff, I can't wait. His blood, the alcohol in it may dissipate. Go draw that blood. So they did. Dude was drunk, got a big DUI charge. Suppression motion was denied when he tried to say, no, you need a warrant. Here's what the Idaho Supreme Court held. Given that he registered a blood alcohol content of 0.234, and again, let's be clear, that's really drunk, right? On a valid breath test, nearly 3 times the legal limit, and he failed all the field sobriety tests, we're skeptical that the state's need for additional evidence rose to the level of a compelling type of situation, right? We hold that the totality of the circumstances known to the officer at the time of the blood draw would not lead a reasonable officer to think immediate action was necessary. In other words, you had the guy nailed dead to rights. You weren't facing an exigent circumstance where you had to also now go dispense with the warrant requirement to draw his blood. You got him. Field sobriety tests. He blew a .234, completely drunk. You're fine. Can't go too far. So there's the example of how DUI and blood draws, got to be careful. Let's shift though from, we've done the dogs, we've done the alcohol, we've done the divorce court judge. Now let's take a quick look at some marijuana. And here we're going to look at whether you've got to get a warrant when you're talking about thermal marijuana imaging of houses. Again, this brings us to the U.S. Supreme Court in 2001, the case of Kylo versus United States, reported as you see here at 533 U.S. 23. So here are the facts. Police officers suspect that there's marijuana inside someone's home, and so they decide we're going to use this thermal imaging device. We're going to scan the building and we're going to figure out how much heat is coming out of the home to see if it's consistent levels of heat with the use of high-intensity lamps, the types of lamps that would grow marijuana in people's closets, right? That like use, I guess, huge amounts of electricity, generate lots of heat. So this home is like pulsing heat. And they have this thermal imaging scan. It sounds like something out of Mission Impossible or something, right? But in any event, they do this. And they do the scan of the house for a few minutes at 3:20 in the morning. They're sitting, in a car across the street in front of the guy's home. And the scan showed that the roof above the garage and a sidewall of the home were seriously hot compared to the rest of the home and were substantially warmer than neighboring homes. So by the way, let's pause there. What that also means is they searched a whole bunch of neighboring homes too by thermal scanning them to kind of see what's the normal heat level of a home in this neighborhood, right? Everyone's getting searched, apparently. In any event, the agent then concluded that this guy's using these, halide lights to grow marijuana in the house. So he, based on those facts, goes and gets a warrant to arrest. They indict. The defendant says, you searched my home with that scanner without probable cause and without a warrant. You should have got a warrant to actually do the search of my home by that thermal imaging device. But the motion was denied. Goes up to the U.S. Supreme Court. What does the U.S. Supreme Court say? They held that the use of a thermal imaging device aimed at a private home from a public street to try to figure out the heat was in fact a search. The fact that we've got sense-enhancing technology in this day and age doesn't mean it's not a search. It was the type of thing that constitutes a search, and you gathered information regarding the interior of the home that was not otherwise obtainable without physical intrusion. Absent a warrant, the Fourth Amendment was violated. So on that one, gotta get a warrant. But what about our next slide here? Police claims of smelling marijuana in another car from their moving squad car. This is another one where you just can't even make up the facts, right? You got a policeman driving along 3:30 in the afternoon in his police cruiser, and he moves into the left lane, and he's behind a Dodge Straus that was being driven by a guy by the name of Gray. And the officer says that from my car driving on the freeway, I could smell a strong odor of raw marijuana coming out of that car in front of me. And so he continued southbound to try to verify that the vehicle was the source of the marijuana aroma. And the cars were not even bumper to bumper, by the way. So there was some traffic there. So it wasn't like he was like up on him even. But nonetheless, they keep moving along, and eventually the defendant moves over to the right lane. And the policeman then says, when he moved to the right lane, I couldn't smell marijuana. And so the officer then switched lanes and got back behind the Dodge Stratus and said, whoa, I can smell marijuana again. And the Stratus Dodge then slowed down, pulls into a parking lot, and the officer said as he turned and went into the parking lot, again, lo and behold, the scent vanished. So the policeman decided at that point, I've got to stop this vehicle and go and do a little bit of a search to go find this marijuana that I've been smelling. And so he does a search, and what does he find? 3.5 ounces of marijuana sealed in a jar and packets inside the car. And so what did the court hold? This comes from the Federal District Court in Indiana in 2021 in the case of U.S. versus Gray, and you see it down there in the lower right-hand corner on our slide. You can see the where you find the opinion. But what the court held, and actually the court had to almost hold its nose. It was almost couldn't believe for a second what it was hearing. It says, The court agrees that it's incredible that the officer, who admits that he doesn't have a heightened olfactory system, it's incredible that he could have smelled the scent of 2 resealable sandwich-sized plastic baggies of unburnt marijuana coming from a moving vehicle when patrolling his cruiser. This is not only contrary to any common experience, but it's actually implausible and seemingly contrary to the laws of nature. And so they granted the suppression motion. So on that one, if a policeman says that he can smell a little bit of marijuana from a sealed bag from his moving car behind another moving car, what the courts are saying is that this actually goes against the laws of nature. No human being's got a nose like that. What are you, a bloodhound? Get a warrant there. Now we're going to take a little bit of a side turn, and we're going to look a little bit more at the exigent circumstances doctrine. And this time we're going to take a look at a case involving the removal of a child from the home. And so this is one of those that's serious when you're talking about removing children from their parents because of potential child abuse. But we're also looking at when you need to get a warrant or when you really confront exigent circumstances. And so these cases become fact-specific and a little serious. So let's take a look at this case. It's Mabe versus the County of San Bernardino. It's reported at 237 F 3rd, 1101, and this is coming out of the Ninth Circuit in 2001. Here are the facts. It's July 19th, 1995. The San Bernardino County Sheriff's Department, they get a call from a woman named Stephanie Rumpler who says, my younger sister, and we use initials here, MD, because she was a minor child, so that's how she's identified in the opinion. So in any event, MD is 14 years old and told her stepsister that she was being molested by her stepfather, Mabe's husband. Mabe is the plaintiff. It's her home that they're all living in. And apparently, MD had reported that the stepfather had touched her breasts and crotch area through her clothing at night in her bedroom, and that this had been occurring every other night for the past few months. And MD had now been was not gone at this time. At the time the report was being made, she wasn't in the home. And so about a month later, after this telephonic report, a county worker, Perry, interviews both Mabe and Mabe's daughter, MD, at their home to find out if Mabe's husband, the stepfather of MD, had been doing it. And according to social worker Perry, Mabe said, nothing's going on in my home, don't know what you're talking about. And what the child said is that, well, something had happened a while ago, but nothing's happened since I returned to the home a month ago or whenever that was, some number of weeks earlier. She had returned and everything had been fine then. So nothing was happening like right now or recently. So the kid said. So what does the social worker do at that moment? And this is why these cases are so fact specific and it's so important to know the facts. Did the social worker in that moment go, this girl's in imminent danger right now, I got to remove her from the home? No. Social worker went home, chilled out over the weekend, hung out, maybe watched some movies, who knows, but took a weekend break and goes back to work Monday morning, sits down and talks to some folks at her office about what had happened last week at the home. And at that moment, for some reason, suddenly decided, oh my, the girl's in imminent danger. I must go get her. So she grabs a sheriff deputy, race down to the home. They don't stop to get a warrant, even though they had 4 days to get a warrant over the weekend and whatnot. They just raced down there and they took the 14-year-old girl into foster custody. This led to a federal civil rights lawsuit, and the question is, was this lawful under the Fourth Amendment? And as you see on our next slide here, the title fundamentally is, was there a sufficient exigency to dispense with a warrant requirement? So let's take a look at what the Ninth Circuit said. Imminent danger of future harm is required to show exigency. Several facts, viewed in the light most favorable to Mabe, undermine a reasonable belief of exigency here. First and most importantly, Perry opted to leave MD in the residence after interviewing MD and Mabe about the alleged molestation. Perry told MD at the end of the interview that she would see if MD needed to be removed from the home. This demonstrates Perry's intent to delay the removal, which raises a serious question about Perry's reasonable belief that MD was in imminent danger. Perry concedes that the improper touching had not been recurring since MD returned over a month after the initial police report was made. And so basically what the court said is this case doesn't present the concern that the child would be concealed or abused in that space of time it would take to get a warrant. I mean, here they had been gone for 4 days, plenty of time to get a warrant if you really thought something was going on here. And so what they held ultimately is that the Fourth Amendment was potentially violated because this is not an exigent circumstance. A warrant was required, and so the case was sent back from this summary judgment appeal to go before a jury. Now we're going to shift to Jimmy Hoffa. Believe it or not, the long dead union guy from the 1950s, 60s, and 70s. He lives on in the 21st century. And actually, it's kind of an interesting case because his case is one involving warrantless seizures and searches of information and the like, which actually has got a pretty significant impact on us in our modern technology age with thermal imaging and all these, the ability to do all manner of searches, geotracing on our cell phones, pinging off of cell towers, TikTok doing whatever TikTok does and all that. So let's take a look at this case. It's a good little case to look at because it lets us wonder how some of the things are going to shake out in the 21st century as we really are confronting these massive new technologies. And so the case is Hoffa versus United States. And this warrant question, do you need to get a warrant, comes out of the basic fact pattern as follows. And you've got the case cite there from 1966, 385 U.S. 293 from the U.S. Supreme Court. So basically, Hoffa's hanging out with someone named Parton. Hoffa didn't know it, but Parton was a secret government informant. He was there to sort of get the goods on Hoffa, so to speak. And while Hoffa's hanging out with this guy Parton, he makes some incriminating statements to him. Kind of caused him some trouble. And this invitee, Parton, what the court said is he relied not on the security of the hotel room, but on his misplaced confidence that Parton would not reveal his wrongdoing. So that's the kind of factual setup in terms of what was going on. Let's take a listen to a few minutes of the oral argument here, because it really is very interesting. And this is the U.S. Supreme Court oral argument from Hoffa versus United States. So listen to this.
The illegality of Parton's repeated entries into Petitioner Hoffa's home suite throughout the duration of the test fleet trial.
Well, that may be agreed upon between you and the government, but I must say I have difficulty understanding why these entries were illegal.
Well, we say they were illegal because, as I will develop in further detail in this argument, Mr. Justice, we say that they were illegal because he was a government agent which was being hidden at the time of these entries into a home for the purpose of looking for evidence that they were therefore illegal, because, as the government agrees with us, an entry into a home without a warrant by deception and an entry into a home without a warrant by force are equivalents under the Fourth Amendment in view of Goulet and the Gopart case.
Well, let's say when a plainclothes detective enters premises to investigate whether or not criminal activities going on there, is that an illegal entry?
Well, if he comes to the door as the helper of the household in the preparation of his defense and as his union colleague, but at the same time is hiding his identity as a government secret agent. Now, if your use of the phrase, Mr. Justice Stewart, of a private detective not connected with the government.
No, I said a plainclothes.
But connected with the government, yes.
Who wasn't obviously a policeman.
Yes. If he enters with deception that conceals his identity as a policeman, that is our position. Well, Your Honor, what they do, as we understand it, and I will advert further to this in the course of my argument, they at no point deny the illegality of the entry. They go further than that and state that in view of the illegal entry, had he been hiding in a closet, these admissions would have been inadmissible, but that the illegality of the entry is immaterial in view of the fact that the statements were directed to him, which I will come to in further detail.
There you had it. Fascinating oral argument. And so here's what the court held. What the Fourth Amendment protects is the security a man relies upon when he places himself or his property within a constitutionally protected area, be it his home or his office, his hotel room or his automobile. It is obvious that the petitioner was not relying on the security of his hotel suite when he made the incriminating statements to Parton or in Parton's presence. So this is really important. Let's stop there. It's not the hotel room that he was relying on. It was the person, right? Hoffa made a mistake. The risk of being overheard by an eavesdropper or betrayed by an informer is probably inherent in the conditions of human society. It is a kind of risk we necessarily assume whenever we speak. So look at that language. It is so broad and it's quite significant when you transport it 50 years forward to where we are today, because this is a very, very broad rationale for what it means to give up your privacy rights. This rationale can engraft onto all manner of technology that we're using, where there's inherent sharing going on by definition, right? There's this digital risk of being overheard all the time. Every time we use our cell phone, GPS data in our Apple CarPlay, it's broadcasting. We get on the internet and go somewhere, it's pinging an IP address with a geolocation of where you're coming from. This is all going on all the time. Is this, that italicized language I gave you from the Supreme Court, the type of risk that's simply inherent in the conditions of human society, right? There it was an eavesdropper who may betray you. Here it's just our devices that may betray us. Do we really have the same levels of expectation of privacy anymore? And that's the fundamental question that Hoffa sort of portends for us today. I mean, where are we giving up our privacy? And is technology going to kill privacy? Hoffa's case, they didn't need to get a warrant because Hoffa chose to speak freely to the person, and that's the risk you take. You incriminate yourself, you better hope the person's not an informant. I guess that's the Jimmy Hoffa case lesson. Now let's go to the next question of getting a warrant. What happens when you call 911 because you need some medical help and the police show up and they turn over and ransack the whole home? That's the case of State versus Turner. This went up to the Georgia Supreme Court, August 27th, 2018. You've got the link there to the case if you want to go look at it. But here's a basic fact pattern. 911 call is made because an infant is unresponsive. EMTs arrive. They take the child and the mom to the hospital. And this is an unresponsive child, like could be dead. So the police also arrive at the same time, and the grandmother's left at the home, and they just start talking to the grandmother. At some point, the police get notified by the hospital that the child had died, but there was absolutely no sign of any foul play or anything that had been done, to the child, like signs of abuse and the like. So the police declared on the spot the home's a crime scene, and the police and the coroner then conducted a search of the home. They videoed it. They took from the home, they seized anything baby related, like clothes, carriers, baby food, you name it. They took it all. And then they indicted the parent for the death of the child. The parent moves to suppress, saying, you didn't have a warrant to do the search. There was not an exigent circumstance here. We never gave consent for that search. And the state appealed. And so what did the court hold? That there's no right to conduct the search without a warrant. The officers admitted at the hearing that they didn't ask for consent to search the home. They didn't ask for consent to photograph or video or remove items. And notwithstanding that failure to ask, at least 4 members of law enforcement, including a crime scene investigator, who no one knew why he was there, right? They couldn't even explain why he was there, participated in a search of the home. And so what they said was, that was an illegal search. Someone calls 911 for medical help. You think something happened? Go get a warrant. Now let's look private sex in the home and get a warrant. Now this is kind of a fun one because this lets us look at the obviously very famous, significant Supreme Court cases dealing with the right to engage in private sexual behavior in our home. So we're going to look at Lawrence v. Texas just to look at the facts, and we're going to intersect them with the Fourth Amendment a little bit, which is quite interesting. So of course, Lawrence v. Texas, it's reported at 539 U.S. 558. It's from 2003. And here's the basic facts. Houston, Texas. Officers get dispatched to a private residence because someone reported a weapons disturbance. They get to the apartment, and what do they find? 2 men engaged in sex. And so what do? They arrest them. The men get convicted under a Texas state law of deviant sexual activity with someone of the same sex. Now, this conviction was challenged on due process grounds, the argument being, I have the right to engage in private homosexual sex with someone else if I want. But here's what's interesting about Lawrence v. Texas. It wasn't challenged on Fourth Amendment grounds. They didn't make the argument that, hold on, does someone reported something about a weapons disturbance, like a gun going off. You don't get to just show up, hear nothing, see nothing, but wander into someone's house, find two people in a bedroom engaged in sex, and arrest them. It's an unlawful search. But in any event, there's no weapons found, and there was no noise at the time when the police arrived, so the entry itself was actually warrantless, and there was no basis for exigent circumstances on those facts. So not only did Lawrence v. Texas affirmatively establish the right of consenting adults to engage in private sexual conduct as they like in their homes with whoever they want of whatever sexual orientation, it's also an example of a case where the Fourth Amendment was brutally violated. It's quite remarkable. And what's particularly interesting about it is that if you stop and look at it through the Fourth Amendment prism, what's pretty clear is loud noises coming out of a house, people maybe having sex, you got to get a warrant. And so let's look at the case, actually, and this is what's so fascinating about it. This is a case Lawrence v. Texas overruled. It was Bowers v. Hardwick, of course, the famous case from 1986, where the U.S. Supreme Court had held the other way. There, the U.S. Supreme Court had said that in the situation where police approached a home, they wanted to go arrest someone for prior public intoxication. They entered the home and they found two men in a bedroom having sex, and so they arrested them all and they got convicted. There, the Supreme Court said there was actually no fundamental right to engage in private homosexual conduct. And again there, no Fourth Amendment challenge again there. So we have all these cases of private sex going on in the home, tripping the Fourth Amendment without the Fourth Amendment being raised. But in any event, at least as it stands today, Lawrence v. Texas is the law, and the police shouldn't be entering no matter what. Fourth Amendment and 14th Amendment say that much. Now, what happens when the home goes from two people having perhaps loud sex to becoming literally a strip club? Believe it or not, this case went to the U.S. Supreme Court too. This is the case of, as you see on our slide here, District of Columbia versus Westby. It's from 2018, and Justice Thomas writes the opinion for the majority. So let's take a look at the facts. Again, like many of these cases involving police entering homes without warrants, they start with noise complaints. So the police arrive at the home, and they show up and they go, this is a party house. And what do they see? And here's a quote from the case. Scantily clad women with money tucked into garter belts. The partygoers claimed that a woman called Peaches was the host of the party. They looked around, they couldn't find Peaches. But what they did see was a bunch of beer cups. They could smell marijuana too. And so they arrested 16 people. And here's another quote from Justice Thomas's facts as the opinion was written. The floor was so dirty that one of the partygoers refused to sit on it while being questioned. In the living room, the officers found a makeshift strip club. And here's what Justice Thomas wrote. Several women were wearing only bras and thongs with cash tucked into their garter belts. The women were giving lap dances while other partygoers watched. Most of the onlookers were holding cash and cups of alcohol. And the officers found more debauchery upstairs. A naked woman and several men were in the bedroom. A bare mattress, the only one in the house, was on the floor, along with some lit candles and multiple open condom wrappers. A used condom was on the windowsill. The police now arrested 21 people for unlawful entry into the home. Now, what ultimately happened is 16 of the 21 turned around and sued and said, you didn't have probable cause to arrest us for being present in a home without permission. In other words, we were just showing up at a party, and Peaches, maybe didn't she own the home, but yeah, we all had the right to be there, and you didn't have a basis to think that there was an unlawful entry just because you found all this stuff. It doesn't mean we unlawfully entered someone's property. Here's what's particularly fascinating about the case. They weren't arrested, it turns out, for prostitution, lap dances without a license, you name it. So let's check out this short little clip. Justice Sotomayor asking some questions at the U.S. Supreme Court oral argument.
Not marijuana or any other. Why weren't people who were suspected of engaging in sex arrested? Why weren't the people standing around the strippers arrested for those activities if they were illegal?
Your Honor, everyone was arrested because the officers believed, and they had probable cause to believe, that everyone in the house had committed the offense of unlawful entry. Specific people in the house may have also committed other crimes.
But they weren't charged with those crimes.
As far as we know from the record, that's right.
There you have it. The case talks more about strippers, money tucked into garter belts, sexual conduct, what's going on? Yet no one was arrested for any of that. They were arrested for unlawfully entering a property they didn't have the right to be on. So, here's what the Supreme Court held. Well, the condition of the house and the conduct of the partygoers allowed the officers to make several common sense conclusions about human behavior. Most homeowners do not invite people over to use their living room as a strip club, to have sex in their bedroom, to smoke marijuana inside, and to leave their floors filthy. I suspect some people could debate that presumption, but in any event, let's take it as a given, because that's what the Supreme Court said. But if that's what the Supreme Court says, you know where this is going. The officers could thus infer that the partygoers knew their party was not authorized. In other words, if you're at someone's home and it's dirty and it's functioning as a strip club, there's people having sex in the bedroom and you're drinking alcohol, you couldn't possibly think you had the right to be there because no decent, good person would ever let that happen in their home. And so that's what the Supreme Court held. And so therefore, the officers did have probable cause to think that these partygoers knew they lacked permission to be in the house. And so when the house becomes a literal strip club, it turns out you don't need a warrant. So that brings our Fourth Amendment program to its end. So let's talk about some of the conclusions here. We started, of course, with the very important premise of the Fourth Amendment, which serves an obviously critical role in our scheme of our republic scheme and our constitution structure and our relationship with our government. And we saw the early case from the early 20th century dealing with warrantless searches and seizures to then use to convict people of sort of like, unlawful behavior and the like. But what we've also seen as we fast forwarded through time and space across our republic is we've seen those lofty, fascinating, esoteric, and heady political philosophy questions get funneled into our modern world. Kind of the modern world almost of sex, drugs, and rock and roll, it turns out, we saw today. And we saw the case of sleeping dogs, Toby the Beagle on his bed. Do you need a warrant to seize sleeping dogs who were violating the leash law? You do. Get that warrant, officers. What about the person who violated the dog leash law and gets arrested and is frustrated down at the jail? Understandably so, I would be too. And then they're told, bend over and cough, strip search time. Get a warrant, officers, on that one too. And of course, I'm just getting divorced. I've got to go before the judge. She gets paid to be a judge. I have the right to get divorced in society. It's her job. My wife and I are fighting over, who's got what property. And the judge says, I'll see you in your home in 10 minutes and searches my home against, seizes my stuff, videos it, takes my phone so I can't video it. No, judge. Get a warrant. That judge lost judicial immunity. And we saw the situation of what happens when you call 911 for medical help and your home gets overrun by the police. Get a warrant again, officers. And we saw the situation of police super noses, ostensibly smelling marijuana from a moving car. Get a warrant. It's a perfect example, actually, of a case where what the court found there, of course, is we will not suspend disbelief to the point of absurdity. DUIs in your own garage. Actually, a very fascinating case there. Or the DUI proof on the breath test, but you drew blood anyway. In both of them, get a warrant. Both of those situations were such that wasn't a basis to automatically treat that as exigent circumstances to yank the blood or search the guy in his garage. He's in his home. And of course, we talked about the strip searches for violating the leash laws. Definitely get a warrant. And finally, we looked at the situation of the recent Supreme Court cases dealing with, of course, the significant due process right in terms of sexual orientation. But the issue of warrantless entries and arrests for loud sex in the home is actually present in those cases. And from a Fourth Amendment perspective, it would be, here's some loud sex, you want to go in? No dice. Get a warrant. Now, what we also saw that was particularly fascinating is if you move from loud sex to someone turning their home into a strip club, as Justice Thomas said, a dirty floored strip club, well, in that case, no need for a warrant to arrest for unlawful entry. So there you have it. And remember, I guess, as the final footnote here, the very important case of Hoffa in terms of its language and the import of that language on our changing technology and how reasonable our privacy expectations can be. Thank you very much for watching this Curious Lawyer program. As always, if you have any questions, please feel free to reach out to me by email. Thank you.